Suck it up, buttercup.
No more tears. I'm done. No, these are
So you have choices.
yes, ma'am. S1 through S9. Yes, ma'am. S1 through S8 are photographs. S9 is a letter.
Are they all here?
Yes. Okay.
Yeah, we have some. Brad. You're not happy.
You tell me.
Yesterday.
Ladies and gentlemen, remain seated and come to order. Court's now back in session.
You may say that. We're back on the record in State versus Krista and Tyler Shinley. Mr. and Ms. Shinley, please rise. Mr. and Ms. Shinley, we're about to proceed in the sentencing in this case. Mr. Shinley, do you still wish to go forward with your guilty plea?
Yes, Your Honor.
Ms. Shinley, do you still wish to go forward with your guilty plea?
Yes, Your Honor.
Okay, you can be seated. Does the state have any legal impact that they wish to submit to the court prior to sentencing?
Yes, sir, Your Honor. I have, Ethan Tyler Shinley is present via WebEx. I'm going to ask him to address the court. I also have, because Evan Shinley cannot be present, I do have a letter from his therapist talking about the impact to him. I also have some photographs that I would like to enter as physical impact evidence. I also have 2 witnesses in aggravation I'd like to present.
Mr. Shinley, Ethan, can you hear me?
Yes, sir.
Okay. Do you wish to address the court, sir?
Yes, sir.
All right, you may do so.
Hi, my name is. Thank you for letting me speak. Ever since I was youth, felt worthless, didn't matter. Now living at home, you know what I am, thanks to the people I have around me. I've learned the truth of Taylor and Elijah. They are all good people at their own time. Overall, it is better thanks to coming up here. When I lived in Georgia, what they did to me, Elijah, and Ellen was very wrong. I hope they can for those things. It was unfair that patient I didn't be for them. I tried to be self-sufficient, but it was never enough. Krista having me with her drivers was asked. Anything I may have done to pay for what they did. At the time, I didn't understand the appropriate punishment and inappropriate punishment, but now I do. I was treated poor. I hope this son will get some reflect on what they could have done differently. And I am faith I can be who I really am her. Even after what they back in I forgive because it's the right thing. Thank you.
Thank you, Mr. Shinley.
Judge, and for purposes of the court record, I will have my office office contact Ethan Tyler and ask him to send a photographic copy of that statement he was reading so it can go to the court record.
Thank you.
Yes, sir. I'd like to call at this time Sophia Gutierrez.
Ma'am, if you'll come around. Do you want sworn?
Yes, please.
Ms. Gutierrez, if you'll come around to the witness stand. Would you come around and raise your right hand? Will you swear or affirm the testimony you're about to give in a matter not pending before this court is true, the whole truth, and nothing but the truth, so help you God? All right, you may have a seat. Please state your name for the record.
Sophia Gutierrez,
Will you spell your last name, Ms. Gutierrez?
Gutierrez.
Thank you. Ms. Gutierrez, what do you do for a living?
I'm a school counselor,
Okay, and where are you a school counselor?
Rock Spring Elementary.
Are you familiar with a child named Haven Gearing, who later was called Evan Shinley?
Yes, ma'am, I do.
Okay. Were you his school counselor when he went to Rock Springs Elementary School?
Yes, ma'am, I was one of his counselors.
Okay. I want to talk to you just a little bit about some things that happened while he was a student there.
Yes, ma'am.
Are you familiar with Tyler and Krista Shinley?
Yes, ma'am, I am.
Okay. During the course of the years that Evan attended school at Rock Springs, did you notice some concerns about food related to Evan?
Yes, ma'am, I did.
Okay. Can you tell me a little bit about those?
His classroom teacher, well, he had some problems with food, and it came about when his classroom teacher said a lot of times when we had some behavior problems, it was all in relations to food. And we got concerned about the amount of food that was in his lunchbox.
Okay. Tell me about the amount of food that would come to school in his lunchbox with him.
So by memory, he used to come with like almonds in a Tupperware container that was like a salad dressing. You know, Tupperware containers, and there were the ones for salad dressing. He would have like almonds in that. Sometimes some celery stick, hummus, but it was always a small containers.
Okay. And after Evan would eat, did he ever seem satisfied?
He was never satisfied.
Okay. Did you address, you and other members of the staff, did you address Evan's hunger with his parents?
Yes, we did.
Okay. And were there times that you had meetings with his parents and with the foster agency and DFACS related to your concerns about Evan's hunger?
Yes, ma'am, numerous times.
Okay. And I want to talk just about those meetings and the steps that you took. Well, Ms. Gutierrez, how long have you been a school counselor?
Since 2016, which was like 8 years.
Okay. And have you dealt with children who came from backgrounds of food insecurity or not having available food?
Yes, we have.
And does hunger sometimes in your experience contribute to behavior issues?
Most definitely.
When you addressed your concerns with the Shinleys about the amount of food that Evan was given, tell me about that interaction between you and the Shinleys.
So one particular instance was he didn't have enough food. There was issues, and we gave him school lunch, and we called. I think I spoke to Dad that day. He didn't have enough food, and so we wanted to provide him with school lunch so that there was no food in the lunchbox. We're not sure. I think, and later on we found out he ate it on the bus or something. And so I called and I got Dad first, and he agreed for us to give him a school lunch. But then we later, Mom was upset that he's not allowed to eat school lunch. You're only allowed to give him what's in his lunchbox because it was on a special diet of some sort.
Okay.
And that was just one instance.
That was one instance.
Yes.
Were there other times where he was observed like licking the bowl, trying to get more food out of what he had?
So on another occasion, during the lunchtime, the cafeteria side, because that's when he came in with the small portions. And one of the paraprofessional in the cafeteria came to report to me that he did not have enough food in the lunchbox, and so the little bit that he had, she was very emotional actually. He was licking the Tupperware, the salad dressing that was in it, clean. but we weren't allowed to give him a lunch from the cafeteria, so she just reported it to me.
Okay. Now, did you, again, confront the defendants, the parents, with concerns about Evan not getting enough to eat?
Yes, we did, and it got to the point where I reached out to the caseworkers about it.
Okay, so you actually reported to DFACS that you had
Yes.
concerns about this?
Yes,
At the time that this was going on, was Evan in foster care with the defendants?
yes.
Okay, so he had not yet been adopted, is that
No.
correct? Okay. Did you express concerns about his adoption to DFACS?
Yes, numerous times.
And besides food, what were those concerns that you had for Evan and his relationship with his, at the time, foster parents, Krista and Tyler Shinley?
So, on one occasion, we had a meeting, IEP meeting, and, during that meeting, it was, a lot was going on, and during that meeting, Ms. Shinley, expressed that everyone was being forced on her. She only wanted, not the exact words, but what she was referring to, that she only wanted the kids, the sister, the twins, and he was being forced on her. And so after the meeting, I emailed the caseworker, and I said, please do not allow them to, and I thought I'd probably get in trouble, but I was like, please do not allow them to adopt him. I don't think they love him.
I want to talk about physical affection with Evan. Did Evan respond to physical affection from his teachers and people in his classroom and stuff like that?
Yes, he loved hugs in the hallway. He was little, so he would always just run up and give us hugs all the time.
And to be fair, the years that he went to school with you are in kindergarten and first grade, is that correct?
Yes.
Were you ever given instructions by the Shinleys related to physical affection with Evan?
Yes, so after, I want to say it was after that meeting and the constant calls and, obviously as the counsel, I was the one making all the reports. I think it got to the point where I think something was said about, I was interfering with the adoption process, because I would consider reach out to the adoption agency or to, the caseworker that was over the case at the time. And in one of the instances, I think it was one of our meetings, Ms. Shirley said that we were giving him too much affection at school, and so he had none left to give him when he got home. And so I was told by our school personnel or administrator that I was not allowed to interact with him anymore. So our other counselor had to, like, if there was any kind of meeting or any talk between the parent and that, or the counselor had to be the one to deal with it, because she reported me to the district office.
Okay, and were you and the other members of the staff at Rock Springs given strict instructions about physical affection with Evan?
Yes, we were not allowed to give him any kind of affection, so there were times when it was just very obvious. I saw him in the hallway and I couldn't hide, so I would still give him a side hug, and there were times when I would hide from him when I see him, so I would not tell him no.
Nothing further?
Any questions, Mr. Carl?
Just briefly, Judge. Good afternoon, Mr. Gutierrez.
Yes, sir.
You made two reports to DFACS about your concerns with the Shins, correct?
I know one specific one. I know Ms. Rice made reports as well. A lot of my communication. I know one specific one that I made. I know the last one I going back. I mean, it's been a while, so I was going back to find all my reports. So I have one that I can remember for sure.
Okay, but do you know there were two investigations done by DFACS? Do you know that?
What do you mean by investigation?
They did two investigations based on your
On report, yes,
report,
okay, yes.
right, from the school. And both of those investigations came back unsubstantiated, correct?
Usually I don't get all the information as to what happened. I just know that when I made it, and a lot of the communication was through email, because we had a caseworker for him for wherever he came from before he came to Henry County. And so a lot of my communication was through her, but yes, we did get a lot of pushback from DFACS.
All right, thank you. That's all I have.
Cross that out.
Second.
Sorry, next one.
State we call Kaylin Carter.
When you come around, let me get you to raise your right hand. Do you swear or affirm the testimony you're about to give in the matter not pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God? United States. Will you state your name for the record?
My name is Caitlin Carter.
Will you spell your first name, please?
Caitlin, C-A-Y-L-I-N.
Morning, or afternoon, Ms. Carter. Can you tell us what you do for a living?
I am a private agency case manager for Families Foster Care Agency.
Okay. And are you familiar with Krista and Tyler Shinley?
I am.
Okay. How are you familiar with them?
I was their caseworker for a year and a half prior to their adoption.
Okay. And were you in charge of the placement of Evan Shinley as well as his 4 younger siblings with the Shinley family?
Technically, that placement authority was with Madison County Defendants. As a CPA agency, we do not have placement authority. We hold the license for the foster family, and we offer extra supervision and support alongside the department.
Okay. Now, I want to talk to you about some concerns that were raised at the time that Evan and his siblings were fostering with the Shinleys, okay? Did you begin to develop some concerns related to conversations with Krista and Tyler Shinley about their relationship with Evan?
Yes, I did.
Can you please tell us about that?
They repeatedly made comments to the effect that they did not want him, that he was a problem. I can remember several specific conversations in their home where they talked about wanting to put a label on him as a foster child so that everyone would understand that they are embarrassed by his behavior and that everyone would give the benefit of the doubt of that it's him, that's the problem. Lots of complaints about behavior, but not specific clarification as to what was going on. It felt a lot more like they were taking anything that happened very personally from Haven, and when we did offer support and resources, they were not followed up with sufficiently, in my opinion. I spoke to multiple supervisors with my agency as well as our agency CEO to intervene and have discussions with the Shinleys about that attitude that they had towards Haven, because I was very concerned about the comments that they were making.
And ultimately, what did your agency do related to the Shinley family?
We recommended against the adoption to the state.
Okay. And did you drop them as a foster family for
We
families
did.
for families?
They had the option of, we would not follow through with the adoption, my agency did not condone it, and so they left our agency and finalized the adoption to DFACS.
Nothing further.
Oh, okay.
Oh, and I'm sorry, you referred to a child named Haven. Is that Evan Shinley?
Haven is Evan Shinley, but I knew him as Haven, and he is Haven in my mind.
Thank you. Nothing further.
Any questions, Mr. Carter?
No.
Any questions, Mr. Booth?
No.
Maybe you may sit down.
Thank you.
Any other witnesses?
No other witnesses, Judge. I do have a few exhibits I'd like to enter, please.
Have they previously been entered in the
They have not.
Okay. There's no need for them to drop in the camera.
Okay. These are state's exhibits S1 through S9. S1 through S6 are comparative photographs from his admission to Children's Healthcare of Atlanta on May 13th of 2023. And then there is a corresponding photo from July 5th of 2023 and a follow-up so that the court can see the difference that proper nutrition made for Evan. There are photographs of his face, photographs of his legs, and photographs of his bottom. The state's position is that these photographs show the physical ramifications of the defendant's actions. F7 is a photograph of Evan now, so that the court can see how he's been able to grow and thrive. S8 is a photograph of Evan with his siblings now, to show that they are working on being able to establish some type of relationship despite the defendant's actions. And finally, states S9. This goes to the mental impact that this had on on Evan. And this is a letter from his therapist, his psychologist, to talk about the impact that it's had. Would the court like me to read it, or would you like to see it? Yes, sir.
S1 through S9 are amended into evidence. Anything else?
Nothing but argument.
Mr. Crawford Hall, do you have any evidence in mitigation?
Just,
Okay. You may argue.
Judge, with regards to Ms. Krista Shinley, we would like to make the court aware that Ms. Shinley has never had any kind of history with the criminal justice system. I don't believe she's ever even had a ticket in her life, but she was a active member of the community. She was an active member of the church. Since she's been arrested, she's been actively ministering to the other inmates in the jail. She's never been a problem. Judge, we would respectfully just ask for you to accept the plea. She does want to make a statement at the appropriate time, Judge.
Now's the time.
I understand that many people came into contact with us through this case and they were affected negatively. And for that, I sincerely apologize to every single person. I know there's people that I have no idea who they even are, and I'm very sorry for that. I'd like to apologize to all of our children. I know the older children have family around them who love them, and I'm thankful for that. And I just pray that God would bring the right parents along to be able to give the younger children a wonderful life. I know that the love of God is able to do many things, and I'm trusting Him with our children, and I'm just very thankful for this opportunity to be able to apologize to everybody.
Mr. Moody, anything in mitigation?
Much like Ms. Shinley had no prior record prior to coming into this, she's been continuously incarcerated since May of 2023. And this is a very tough and trying case around all of this. There's not been anything that's easy about this case. As the court's even seen through the process of jury selection and just the one day of testimony. This was a soul crusher, so to speak. But with this plea, I'd ask court to take into consideration that the Shins have essentially eliminated the necessity for the children to testify to go through any sort of cross-examination or other hardship. Also, essentially now taking what would have been 2 weeks of trial now to just a week on this, and they have come forward and accepted responsibility in this case. So I
please rise.
I don't think there's really any words really expressed, feelings of just this whole situation where just want to be a parent and love kids, and things happen, and sometimes you wish you could turn back time and make different things change, But I'm very thankful that, granted, I didn't get to see the images, and I'm glad that I got the help that he needed to.
You don't deserve to see the images.
I didn't. I'm just glad that he got the help that he needed, and I pray that they all get homes that they need to be in, and I apologize for all my family and friends and everybody I've ever associated with that got to go through this, and all people that I don't even know that's been affected by this. So just my apologies, and just continue to pass the race.
Are you from the state?
Your Honor, I've been prosecuting nearly 18 years, the majority of that prosecuting crimes against children, and never have I seen a case that showed the depths of human depravity like this one. The depth of torture that Evan Shinley lived through for years at these two hands is truly terrible. Our Constitution does not allow us to do the types of things to them that they chose to do on a child. When they go to the Department of Corrections, they will have rights. They will have access to dental care and hygiene. They will have access to toilet paper and running water. They will have access to food and medical care. Their every need will be met. And that was their job for Evan. When he was placed with them, he was only 5 years old. By the time he was 10, he weighed 37 pounds because they systematically took everything from him. They took food, they took his health. He went from being in the 75th to 90th percentile in weight to 0.01 percentile by the time they were finished with him. This jury would have heard that. This jury would have heard from the dentist that had to extract his teeth. This jury would have heard from the endocrinologist that treated him that the only thing that made him look the way that he looked was malnutrition. There was not a thing wrong with his body other than the fact that it was starved. He was starved with food. He was starved with basic necessities. Most distressing, he was starved of his humanity. Because they constantly told him he was disgusting. They fed him rotten food and encouraged the other children to laugh at him. They told the other children that he was gross and not to spend time with him. They encouraged the other children to call him names. They called him names. Dipshit, worthless, disgusting. That is what Evan Shinley lived with in that barren room that the court saw with the door locked from the outside. I know that the court cannot, in any means, do justice for what Evan Shinley lives through. It's not in our authority, and it is not here on this worldly plane. I am asking that the court do its very best to honor what Evan Shinley lived through, to honor what Ethan Tyler Shinley lived through, because what the court didn't hear from Ethan Tyler today is that he was used as a weapon against Evan, just like those younger siblings. He was required to enforce the rules, and as a child with autism, he did absolutely everything he was told to do. The time that he was cut with a knife, and he didn't tell the court this, was because he took a popsicle. Everything in that house centered around control. absolute obedience to the word of law. Well, the word of law does reign, and it reigns here in this courtroom, and it reigns from that bench. I'm asking you, speak it. Speak the word of law. I have nothing else. Thank you.
Mr. and Ms. Shinley, I've been an attorney for over 20 years. Much of that time I was a prosecutor. I've seen people do heinous things to each other. I've seen people with their head almost cut off. I've seen murders. I've seen child molestation. I've seen child pornography. I've even prosecuted a child death where the child was tortured. But as I sat here yesterday, I thought to myself, I've never seen human beings do what you two did to another human being. I have a special needs son who's autistic. God placed him with me as a blessing. Many people don't have the blessing to have children. There's probably some here in court today that don't have that blessing. And we threw it away. When Evan ran away from your residence, Miss Shinley, and you were stopped by the police, you never even asked, is Evan okay? That would have been the first thing that I would have asked if one of my children were missing from my residence. And to sit here and listen to testimony where your adopted son, your son, was so hungry that when he was given food at the hospital and crumbs dropped into his napkin, he was so scared that that napkin full of crumbs was going to be taken away. And while I appreciate you not putting your children through this process and making them testify, you sure shown a hell of a time to show mercy on this. When I became an attorney, like Ms. Leonard said, we took an oath to uphold the Constitution of the United States and the Constitution of the State of Georgia. Under the 8th Amendment, I'm not allowed to impose a sentence that is cruel and unusual. I'm bound by that oath, and I'm bound by the Constitution. You better be glad that I am. Or otherwise I would impose a sentence much like the one you imposed on Evan. But that's beyond my authority. I'm taking into account the fact that you did not put your children through this process. I'm also taking into account that you have chosen to accept responsibility in day 2 of this trial, or day 2 of testimony in this trial. Had this case gone further, you would likely be receiving a sentence much higher than what you are about to receive. With that being said, please rise. Ms. Shinley, on count 1, criminal intent to commit a felony, the court finds you guilty. The sentence on that count will be 20 years to serve in prison. On count 2, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve in prison, consecutive to count 1. On count 3, cruelty to children in the first degree, the court finds you guilty. The sentence on that count will be 20 years probation, consecutive to counts 1 and 2. You'll have the following general conditions of probation. Do not violate the criminal laws of any government unit avoid injurious or vicious habits, avoid personal places of disreputable or harmful character, report to the probation officer as directed and permit such officer to visit your home or elsewhere, work faithfully at suitable employment insofar as may be possible. Do not change your present place of abode, move outside the jurisdiction of the court, or leave the state for any period of time without prior permission of the probation officer. Support your legal dependents to the best of your ability. You'll have a Fourth Amendment waiver. You'll submit to a search of your person, residence, papers, vehicle, and or effects at any time, day or night, with or without a search warrant, whenever requested to do so by a probation officer or other law enforcement officer, upon reasonable cause to believe that you are in violation of your probation, otherwise acting in violation of the law. You shall specifically consent to the use of anything seized as evidence in any judicial proceeding. You will have absolutely no contact with the victims and witnesses in this case, including your own children. You will sign a records release which will allow the probation office to have access to all your medical, clinical, treatment, and work records. As part of this probation, you are banished from the Griffin Judicial Circuit, which includes Upton, Pike, Spalding, and Fayette counties. You will provide a DNA sample. This is an offense against a minor. You will have no contact with minors and not be allowed to be around where minors congregate. You will avoid alcohol and drug use, and you shall not possess firearms. On count 4, aggravated battery, the court finds you guilty. The sentence on that count will be 20 years to serve, concurrent to counts 1 and 2. On count 5, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 4. On count 6, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 5. On count 7, battery, the court finds you guilty. The sentence on that count is 12 months to serve, concurrent to counts 1, 2, 5, and 6. On count 8, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, and 7. Count 9, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, 7, and 8. On count 10, aggravated assault, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, and 9. On count 11, aggravated assault, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, 9, and 10. And on count 12, aggravated battery, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, 5, 6, 7, 8, 9, 10, and 11. Now, Ms. Shinley, you have the right to appeal this plea. If you wish to appeal this plea, you must file that paperwork within 30 days of today's date. Your attorney will go over that with you. Ma'am, you have pled guilty to felony offenses and misdemeanor offenses. With respect to the misdemeanor offense, you have 12 months from today's date to avail yourself of relief under the state's habeas corpus act. With respect to the felony offenses, you have 4 years from today's date to avail yourself of relief under the state's habeas corpus act. Your attorney will go over that with you. Ms. Shinley, do you wish to withdraw this guilty plea and have a jury trial? That'll be the sentence of the court, ma'am. Mr. Shinley. On count 1, criminal intent to commit a felony, the court finds you guilty. The sentence on that count is 20 years to serve in prison. On count 2, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve in prison, consecutive to count 1. On count 3, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years probation, consecutive to counts 1 and 2. You have the following general conditions of probation. Do not violate the criminal laws of any government unit. Avoid injurious or vicious habits. Avoid person or places of disreputable or harmful character. Report to your probation officer as directed or permitted by such officer to visit your home or elsewhere. Work faithfully at suitable employment. Do not change your present place of abode, move outside the jurisdiction of the court, or leave the state for any period of time without permission from your probation officer. Support your legal dependents to the best of your ability. You will have a Fourth Amendment waiver. You shall submit to a search of your person, residence, papers, vehicle, and or effects at any time, day or night, with or without a search warrant, whenever you're requested to do so by a probation officer or other law enforcement officer, upon reasonable cause to believe that you're in violation of your probation or otherwise acting in violation of the law. You shall provide a specimen for testing at the request of your probation officer. You're to have no contact whatsoever with any victims or witnesses in this case, including your own children. You will have a records release or sign a records release so that your probation officer can get all medical, clinical, and treatment records. You're banished from the Griffin Judicial Circuit, which includes Upson, Pike, Spalding, and Fayette counties. You will provide a DNA sample. Mr. Shinley, this offense is against a minor. You will not be allowed to be around minors or where minors congregate. You're to avoid alcohol and drug use, and you shall not possess firearms. Mr. Shinley, on count 4, aggravated battery, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1 and 2. On count 5, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 4. On count 6, cruelty to children in the first degree, the court finds you guilty. The sentence on that count is 20 years to serve, concurrent to counts 1, 2, and 5. On count 7, battery, the court finds you guilty. The sentence on that count is 12 months to serve, concurrent to counts 1, 2, 5, and 6. On count 8, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, and 7. On count 9, false imprisonment, the court finds you guilty. The sentence on that count is 10 years to serve, concurrent to counts 1, 2, 5, 6, 7, and 8. Mr. Shinley, you have the right to appeal this plea. If you wish to appeal this plea, you must file that paperwork within 30 days of the day's date. Your attorney will go over that with you. You're pleading guilty to a misdemeanor offense and felony offenses. With respect to the misdemeanor offense, you'll have 12 months from the day's date to avail yourself of relief under the state's habeas corpus act. With respect to the felony offenses, you'll have 4 years from the day's date to avail yourself of relief under the state's habeas corpus act. Your attorneys will go over that with you. Mr. Shinley, do you wish to withdraw this guilty plea and have a jury trial? That'll be the sentence of the court. You can take him out. Anything else we need to take up from the state before I bring this jury in and release them? Anything from the defense? No. All right.
Judge, I do actually have one request. I would ask that the jury be allowed to see the photograph of everything else, so that they can see.
I'll allow you to publish them to the jury. I think it would probably be better, I'm not trying to tell you how to track a case state, but given the way the pictures looked on the TV, I would probably much rather than see them in their hands. You can bring the jury in. You may be seated. Ladies thank the gentlemen of the jury. I can assure you that we have been working diligently while you have been in recess. Mr. and Ms. Shinley have entered guilty pleas this morning to all of the charges. I have sentenced each of them to 40 years to serve in prison, followed by 20 years on probation. They also received maximum sentences on the remaining charges to run concurrent. They are banished from the Griffin Judicial Circuit if and when they come out of prison and are on probation. The court was willing to accept their guilty plea. They had the absolute right to enter a guilty plea at any time before a jury renders verdict. They chose to exercise that right this morning and to avoid any further evidence coming before you and before their children had to take a stand. These types of cases are hard on everyone involved, including jurors. And I can only imagine how you felt last night after seeing the evidence that you saw yesterday, because I felt the same way. That being said, I'm able to release you from your service this week. Again, on behalf of all of the judges of the Griffin Judicial Circuit, I want to thank you for your service. We simply can't do business without jurors who honor their summons and come to court. The state would like to show you some pictures of how Evan looked before and how he looks today. If you're willing to indulge us, I think it would better your soul. It sure did better mine. Ladies and gentlemen, again, I want to thank you for your service this week. You will receive your check in the mail from the clerk's office. It's a mere pittance for your service here this week. In other words, don't spend it all in one place. With that being said, you can leave your juror notebooks and your juror badges with the bailiffs. You're now released from my order as far as conducting any research about the case, speaking with anyone about the case. You may speak freely with whoever you wish. And again, I thank you for your service, and you may now be released. If you need a work excuse, you can get it from the clerk's office downstairs on the first floor. Thank you.
Thank you all very much. Thank you.
matters we need to take up from the state?
Nothing from the state.
Any from the defense?
No, Judge.
We'll be in recess till Monday morning. Next up.
Thank you.